Good afternoon. The Subcommittee on Courts, Administrative Law, and Commercial Law will come to order. Good to have the panel with us. I'll give my opening statement and recognize Mr. Cohen, and also Mr. Conyers, I think, is with us as well. Most economic experts argue that small businesses and small business trends drive and shape our economy, which in my view is probably the most important issue confronting our country today. Small businesses are the source of almost half of our workforce, and while I'm concerned about many economic factors, it's also my view that the government regulations have an inordinate impact on small businesses particularly. While all businesses have to comply with municipal codes and permitting, county codes and permitting, state codes and permitting, federal regulations can impose an even greater burden because most small businesses simply don't have the resources or the time to dispute or participate in the federal regulatory process. According to the Small Business Administration, businesses with fewer than 20 employees spend on average 36% more per employee than do larger firms to comply with federal regulations. The SBA also claimed that these small employers represent 99.7% of all businesses and have created 65% of all new jobs over the past 15 years. Although it's clear that our economy may be showing signs of improvement, we're still suffering from job losses, lack of job creation, or wherever you'd like to describe it. It makes sense that we look to small businesses and work to create an environment that will help them prosper. Or should I say, try to improve the environment in which they're currently struggling to survive. I know that everyone here today supports small businesses and that everyone in this hearing room also wants to enact something that will help create jobs and economic growth. I sponsored H.R. 527 because I believe that improving the Small Business Regulatory Enforcement Fairness Act and the Regulatory Flexibility Act will have a lasting impact on small businesses and help support long-term small business growth. Small businesses want and need our help, and it's our responsibility, it seems to be, to ensure that our regulations are appropriate and in order and that our regulatory process is effective. Admittedly, I don't claim to be an expert on regulatory law, and I'm anxiously awaiting the testimony of today's witnesses. Of the many questions I have for the witnesses, I want to know most whether this legislation will help or empower small business enough in the regulatory process. If it does not, I'd be interested to know what needs to be done to change the bill to make it more effective. I'm also very interested to hear about any concerns that the witnesses have about this legislation. Look forward to hearing from our panel and reserve the balance of my time, and I'm pleased to recognize the distinguished gentleman from Tennessee, the ranking member, Mr. Cohen.
Thank you, sir. I appreciate the recognition. Small businesses have a significant part of our nation's economy, and everybody knows they're so important for our nation's health. According to a March 2010 Small Business Administration report, firms employing fewer than 500 employees employed over half of the private sector workers in 2006. Additionally, small businesses can be drivers of innovation and economic growth as well. It's interesting to note, though, that both of these facts, the 500 employees, the over half of the growth, et cetera, have been true under the existing regulatory system that has been in place since 1980, when the Regulatory Flexibility Act was enacted. Despite the testimony that we will hear today about how the RFA has been ineffective at stemming overbearing regulations that stifle small businesses, the fact is that small businesses have done well in the almost 36 years since the RFA, as amended in '96 by the Small Business Regulatory Enforcement Fairness Act, has been in place. I'm concerned that the bill that's the subject of today's hearing, H.R. 527, the Regulatory Flexibility Improvements Act of 2011, may be a solution in search of a problem. In fact, it's very similar to a bill introduced in 2003, apparently to get at the oppressiveness of the Bush administration's regulations on small business. In the written testimony, the three majority witnesses all cite the same study by Nicole and Mark Crane that claims the federal rulemaking imposes a cumulative cost of $1.75 trillion on the nation's economy. Mr. Schull will one of our witnesses, will rebut the particulars of that study, I'm sure. But I will note that the Center for Progressive Reform, among others, has debunked the Crane study thoroughly, noting the study does not account for any benefits of regulation, and it's relied on suspect methodology in reaching its conclusions. I would like to ask unanimous consent, Mr. Chairman, that the CPR report entitled Setting the Record Straight, the Crane and Crane Report on Regulatory Costs be entered into the record.
Without objection.
Thank you, Mr. Chairman. Unfortunately for the proponents of H.R. 527, the Crane study appears to be the only statistical evidence that they can cite or can be cited in support of this notion that regulations impose undue cost on small business. While I don't dispute that regulations can impose cost and that cost-benefit analysis is a valuable tool for ensuring that agencies promulgate good regulations, I remain skeptical as to the degree of the purported problem as the proponents of H.R. 527 suggest. I also take issue with the notion that the federal regulations are to blame for what remains an unacceptably high unemployment rate. If anything, current employment problems can be traced to a lack of adequate regulation of the financial services and housing industries, which allowed for reckless private sector behavior that just about everybody recognizes as the cause of the Great Recession, the 2008 financial crisis, that most severe economic recession since the Great Depression. It was the lack of regulation that hurt us, not regulation. Almost anything that can stand, anything can be stand to be improved, and I'm open to suggestions on how we can improve our regulatory process, particularly how it relates to small business. But H.R. 527 proposes some needlessly drastic measures that threaten to undermine public health and safety and waste public resources. I point to three particular examples. First, I'm concerned about the requirement that as part of the regulatory flexibility analysis, agencies must consider the indirect effect of a proposed or final rule. Although the bill attempts to put some sort of logical limit on this requirement by specifying that the required analysis be restricted to those indirect effects that are reasonably foreseeable, that qualification is insufficient. Asking what is indirect and what is reasonably foreseeable still requires highly speculative analysis. Forcing agencies to devote limited staff and resources to engaging in such type of unwieldy, indeterminate, and speculative analysis, which would constitute nothing more than a guessing game, is a waste of taxpayer money, putting government workers and more to work on issues that are not going to result in an aid to our economy or small business. Second, I'm troubled by the repeal of agencies' authority to waive or delay their regulatory flexibility analysis in the event of an emergency. If we are truly concerned about flexibility in the rulemaking process, then at a minimum, agencies ought to retain the ability to respond to an emergency. The rationale for repealing this emergency authority is not clear, at least not to me, other than as a general attack on rulemaking. Third, I'm concerned that H.R. 527's look-back provision is simply a backdoor way for special interests to undermine existing health and safety regulations. You know, the Clean Air Act was passed and the EPA created by a Republican president, Richard Nixon, one of his crowning achievements other than making the trip to China. As Mr. Schulz notes in his written testimony, agencies would be forced to re-justify longstanding rules ensuring the safety of the air we breathe, the water we drink, the food we eat, the products we buy, and the places we work. Rule that most Americans support, and rules that need to be maintained for the health and safety and welfare of the American public, which is part of the government police powers that need to be maintained, enforced, and strengthened for the benefit of all. I'm open to ideas on tweaking the regulatory process in modest ways to make regulatory compliance easier for small businesses and perhaps finding better ways for small business to provide input to specific rules. As drafted, though, H.R. 527, a redraft of a 2003 law that's dusted off with a 2006 law, now introduced as a 2011 law, simply goes too far and hasn't changed much in 8 years. Thank you, Mr. Chairman. I yield back the remainder of my time.
I thank the gentleman. The chair recognizes the distinguished gentleman from Michigan, the chairman emeritus of the House Judiciary Committee, for an opening statement.
Thank you, Chairman Coble. I'm happy to be serving on this committee, and I repeat my congratulations to you for assuming the chairmanship of this committee. You're a senior member of judiciary, and we respect that so very much. Now, on January 24th, our subcommittee had hearings on the RAINS Act. Now, this was our colleague from Kentucky, Jeff Davis's notion that all regulations ought to be approved or disapproved by the Congress. And apparently the notion of the separation of powers doctrine could be set aside in this instance, because I don't know how in the world, after we pass a law, obligate the appropriate federal agency to deal with it. We then say that any regulations has to be approved by us. So we come back and we legislate on what they're doing to implement the law that we passed in the first place. Your speed, Chairman Coble, is remarkable, because you introduced this bill, and here we are 2 days later holding hearings on it. I envy that. I tried to do that when I was chair of this committee, and I was a miserable failure. We never could move with that kind of speed. So, of course, I yield. Oh, Smith, this is, well, then that explains the speed then. This chairman is swifter than the... No, this chairman is swifter than the previous chairman. And I will discuss this with Lamar, but here's what I'm looking at. In addition to what Steve Cohen just talked about, an incredible cost that is alleged to be occurring, the whole notion that this would cost almost $2 trillion is, well, I'll just read the one quote from here. It's easy to see why the anti-regulatory critics have seized on the Crane and Crane report and its findings. That's the one that Mr. Cohen just put in the record. The 1.75 trillion figure is a gaudy number that was sure to catch the ear of the media and the general public. Upon examination, however, it turns out that the 1.75 trillion estimate is the result of transparently unreliable methodology and is presented in a fashion calculated to mislead. I'd like to ask all of the four witnesses to be prepared to respond to this at any time during this hearing. The other matter is the OMB watch statement on the Regulatory Flexibility Improvements Act. And they list 5 problems that deeply concern them about this proposed legislation. 1, it adds yet another analytical layer to the rulemaking process, further complicating agencies' ability to implement statutes, fulfill their missions, and serve the public interest. This measure before us gives more power to the Small Business Administration Office of Advocacy, which is in fact an office of taxpayer-subsidized industry lobbyists who funnel the objections of businesses into agency decision-making. 3, it politicizes important decisions about public protections, potentially allowing economists in political offices to overrule agency scientists and other experts. For it would actually make it more difficult for agencies to review and revise existing regulations by forcing agencies to use a formula to decide which rules to review rather than reviewing the rules at their discretion. And finally, it's an unfunded mandate, asking much of agencies but authorizing no additional resources. Get the picture? I do. And that's why this is so important. I'm concerned that in this time of fiscal restraint, this bill will result in wasting public resources. And there are several other reasons that I'd like to bring to your attention, but I think I can bring it up safely in the course of our discussions. And I thank Chairman Coble for his generosity in terms of time.
I thank the gentleman, and all other opening statements will be made a part of the record without objection. We're pleased to have an outstanding panel today. I will introduce them from my left to right. Mr. Richard Gimbel is the president and third-generation owner of Atlas Machine and Supply, Inc., based in Louisville, Kentucky. The company is 104 years old and has branches in Ohio and Indiana. Mr. Gimbel says of his position, it's my responsibility to do all I can to grow, strengthen, and improve the company, and then to pass it on. And his son, Richard Gimbel III, heads the company's engineering division. In addition to presiding at Atlas Machine and Supply, Inc., Mr. Gimbel sits on the board of directors at the National Association of Manufacturers, and he received his MBA from Balmoral University. Am I pronouncing that correctly, Mr. Gimbel? Balmoral? In Kentucky. Good to have you with us, sir. Mr. Thomas Sullivan is of counsel at Nelson Mullins Riley and Scarborough, LLP in Washington. Mr. Sullivan also heads the Small Business Coalition for Regulatory Relief. In the past, Mr. Sullivan served as chief counsel for advocacy at the Small Business Administration, worked with the National Federation of Independent Business, served on congressional affairs staff of the U.S. Environmental Protection Agency, and was an official of the University Department of Justice, Environment and Natural Resources Division. Mr. Sullivan earned his Juris Doctor degree from Suffolk University School of Law. Mr. Robert Scholl is our third witness and is a program officer for workers' rights at the Public Welfare Foundation in Washington, D.C. Prior to coming to the Public Welfare Foundation, Mr. Scholl was the deputy director for auto safety and regulatory policy at Public Citizen and director of regulatory policy at OMB Watch. Our fourth witness, Ms. Karen Harned, is the executive director of the National Federation of Independent Business Small Business Legal Center. Prior to coming to NFIB, Ms. Harned worked as an associate at Olson, Frank, and Wheaton, PC, and on the staff of Senator Don Nichols of Oklahoma. She earned her BA degree from the University of Oklahoma and her JD degree from the George Washington University School of Law. Now, I am told that there is a floor vote imminent, so we'll have to just wait until the bell rings. Ladies and gentlemen, we try to comply with the 5-minute rule, and we try to apply that to us as well as to you all. So when you see the amber light appear in your face, you will know the ice on which you're skating is getting thinner. But nobody will be keel-hauled for violating. But we would appreciate your staying within the 5-minute rule if you could. When the red light appears, that is your warning that the 5 minutes have in fact expired. Good to have each of you with us. Mr. Gimbel, why don't you kick it off?
Well, Mr. Chairman, I appreciate the opportunity to be here, and I kind of feel a little out of place. I'm probably the only person up here that doesn't do this for a living. I mean, I run a machine shop, so I hope you'll bear with me.
We will indeed.
In that regard. My company, Atlas Machine, is based in...
Mr. Gimbel, pull that mic a little closer to you, if you will.
Yes. My company is Atlas Machine and Supply. We're based in Louisville, Have 200 employees, 104-year-old company, fourth generation now with my son taking over in engineering. I also serve on the board of the National Association of Manufacturers and am pleased to testify on their behalf today. The United States is the world's largest manufacturing economy. It produces $1.6 trillion of value each year and employs 12 million Americans working directly in manufacturing. On behalf of the NAM and the millions of men and women working in manufacturing in the United States, I want you folks to know that we support your efforts to reform the RFA and to unleash the small manufacturers of this country to do what they do best, which is to make things and create jobs, and I might also add, to pay taxes. Manufacturers have been deeply affected by the most recent recession. This sector lost 2.2 million jobs during this period. Our own company suffered the worst downturn since the Great Depression. So far, only 6.2% of these jobs have come back. And the numbers show that American manufacturing is growing more slowly than in the countries we have to compete with. We have seen policies from Washington that will not help our economic recovery and can actually discourage job creation. Some are proposed policies that fortunately have not yet been enacted, such as huge increases in the individual income tax rate, the Employee Free Choice Act, the so-called cap-and-trade legislation. We still face threats from an EPA that we believe is out of control, and a health care mandate that appears to make the business health care burden even worse. All of these will worsen our ability to compete as a nation. To regain manufacturing momentum and to return to net job gains, we need improved economic conditions and we need improved government policies. In recent years, many of us in manufacturing have transformed our operations. We've adopted a Japanese principle some of you may have heard of. It's called lean thinking. The concept is very simple. You just identify everything in the organization that consumes resources, that adds no value to the customer. That's called muda, or waste. Then you look for a way to eliminate the muda. Our modest proposal is that the government learns from manufacturing and incorporates lean thinking into the regulatory process. Many of the proposals that are being offered by this subcommittee, including more detailed statements in the RFA process and requirements to identify redundant, overlapping, or conflicting regulations, will do just that. My written statement details our support for amendments to the periodic review requirements of the RFA, thus applying lean thinking and continuous improvement, another manufacturing principle, to the regulatory process. It's crucial that agency action be made mandatory when these inefficiencies are identified. The gains could be tremendous, as we've found on the factory floor. My written remarks also detail examples of the damage to be done by runaway regulation at the agency level, including the EPA's ozone proposals. One estimate is that the most stringent standard under consideration would result in a loss of 7.3 million jobs by 2020 and $1 trillion per year in new regulatory costs beginning in 2020. Manufacturers hope that this legislation is just the beginning of a more thoughtful regulatory system built on common sense with an understanding of modern manufacturing. A few days ago, the President appeared before business leaders here in Washington. He urged us to get in the game, those were his words, and to invest in growth and job creation. And I'm here to tell you we would love to do just that. But we don't invest our personal assets just because somebody, even the President, tells us we should. We do so because we believe the environment is right and that good opportunities exist for return on the investment and job creation. Many of the NAM's members are family businesses like our own. We want to invest to grow. That's why we exist. But when our government creates policies, laws, and regulations that increase the cost of doing business, the natural reaction by small businesses in particular is to simply hunker down and wait things out. Manufacturers in the United States created the middle class. We can regain our momentum with the right policies in place. I'm confident that our nation's leaders will take action to promote and not increase the risks of investment and job creation. And the NAM stands ready to assist you in this effort. Thank you, and I'll look forward to any questions.
Mr. Sullivan?
Thank you, Mr. Chairman. Members of the subcommittee, pleased to present testimony in strong support of H.R. 527, the Regulatory Flexibility Improvement Acts of 2011. I'd like to briefly summarize, so I ask that my full written statement be made part of the record.
Without objection.
There are three basic reasons for the Regulatory Flexibility Act. One-size-fits-all federal mandates do not work when applied to small business. Second, small business face higher costs per employee to comply with federal regulation than their larger competitors. And third, small business is critically important to the American economy. The Regulatory Flexibility Act has not worked as well as it can to address regulatory challenges faced by small business. That's why I support H.R. 527 and how it will improve the law's effectiveness. Before I get into detail about the provisions in the bill that are particularly important, I want to point out why there's an immediate need for these reforms. In the last 2 years, the federal government issued 132 economically significant regulations. Rulemakings are not slowing down either. There are 181 more regulations underway now than there were last year, representing a 5% increase in activity. According to plans issued recently by regulatory agencies, there is a 20% increase in significant regulations currently under development. As far as H.R. 527 and its benefits on how it will improve the Regulatory Flexibility Act, currently, the law requires agencies to analyze the direct impact a rule will have on small entities. Unfortunately, limiting the analysis to direct impacts does not accurately portray how small entities are affected by a new federal rule. For instance, when EPA's greenhouse gas regulations impose a direct cost on an electric utility, EPA should make public how its proposal will likely affect the cost of electricity for small businesses. I believe the rulemaking process is shortchanged by not including discussion about the obvious ripple effects of regulations on small business, and H.R. 527 tries to correct this. All agencies should utilize small business advocacy review panels. When I was chief counsel for advocacy, I did not think that the Regulatory Flexibility Act needed to be amended to force every agency to convene small business panels the way that EPA and OSHA do under the Small Business Regulatory Enforcement Fairness Act. I thought that agencies could do a good enough job soliciting input from small businesses on their own. Now, I realize that some agencies will resist formally soliciting help from small entities prior to issuing proposed rules. Requiring the Consumer Financial Protection Bureau that was created by the Dodd-Frank Financial Reform Law to have to use the small business panel process made sense. That's why it was passed into law. The same logic applies across the board to all federal agencies, and that's why the small business panel process under the Small Business Regulatory Enforcement Fairness Act should become the norm, not the exception. The Small Business Administration's Office of Advocacy should clarify definitions in the Regulatory Flexibility Act. Disputes over whether an agency's proposal will, quote, will impose a significant economic impact on a substantial number of small entities, end quote, have limited the effectiveness of the Regulatory Flexibility Act. H.R. 527 addresses this problem by giving the Office of Advocacy rulemaking authority. The rules promulgated by the Office of Advocacy will better define how agencies are to properly consider small business impacts, and that will benefit the process in two ways. First, it will minimize confusion over whether agencies are properly considering small business impact. And second, rulemaking authority by the Office of Advocacy will confirm the primacy of the Chief Counsel for Advocacy when courts ultimately render opinions on the Regulatory Flexibility Act. The periodic review of regulations under the Reg Flex Act should be improved. H.R. 527 will bolster the effectiveness of the look-back provision by broadening the number of rules agencies will review, requiring transparency of those reviews, and by better defining the process through the Office of Advocacy's rulemaking. There are additional reforms that Congress can consider to benefit small business. I'm happy to work with this committee to explore additional legislative efforts beyond amending the Reg Flex Act that will help create an economic climate where small businesses have an easier time growing and creating jobs. Thank you.
Thank you, Mr. Sullivan. Mr. Shull, I was in law school long, long ago with a chap whose surname was Shull. Do you have Carolina kin?
That's not I don't, I don't know. There's a large network of Schulls out there whose connection with our Schulls, we don't know yet.
Well, he was a good fellow. He had high honors in law school. You recognize Mr. Shull?
Well, then I have quite an act to live up to then. I want to thank you for the opportunity to testify. These are very important issues for small business owners, for their families, for their communities, for their customers, for their workers, for really all of us. And I want to start with the proposition that agencies don't regulate for the sake of regulating. They regulate because they have been charged by Congress with the task of getting things done to protect the public. And to protect the public's health, its safety, the environment, the air we breathe, the water we drink, the food we eat, the products we buy, the traffic conditions in which we all drive, the jobs that we go to. These are important tasks. And there are new regulations in the works. There will always be new regulations in the works because the world is changing. And as the world changes, we discover that there are unmet needs for public protection. And I'll give you an example. In the world of auto safety, thanks to important regulations like the mandates for seat belts, mandates for airbags, mandates for side impact protection, even so simple a rule as the fact that the steering column collapses now, whereas it used to be a solid piece of metal that would impale the driver in some crashes. Now, all of that means that people are coming away surviving crashes that just years ago they wouldn't have been able to survive. But we're increasingly discovering, because people's lives are being saved, that there are still new needs to protect vehicle occupants in crashes. For example, because they are now surviving a larger number of crashes, we're increasingly discovering that they're coming away with injuries to their lower extremities, to their legs and their feet, which opens the door to the fact that there may not be sufficient protection at the bottom of the car, the tire wheel well and intrusion into that part of the crumple zone of the vehicle. And so the National Highway Traffic Safety Administration should be looking at that and should be developing new regulations in that regard. Automakers have increasingly computerized motor vehicles. They're becoming more and more like computers on wheels. A new research report found that some of these computer systems, which control, in some cases, really critical functions of an automobile, like the brakes, can be hacked by folks outside of the car. So it really behooves the NHTSA to start looking into whether or not the performance of these computerized components are adequately protecting vehicle occupants. So the fact that there are new regulations on the book doesn't necessarily mean that we have runaway agencies. It just means that we have agencies that are doing what they're supposed to do, assessing the public's unmet needs and assessing what needs to be done to protect the public. I also want to start with the proposition that small businesses, I think we all agree, are vital. Small businesses also are owned by small business owners who have families, who live in communities, who have employees, who have coworkers and neighbors, who themselves are breathing this air, drinking the water, eating the food, buying products, getting out on the road, and going to work every day. They receive the benefits of regulation, not just shoulder the burden of its costs. And we hear a lot about costs today, but one of the assumptions that seems to be here in the RFIA is that analysis and review and all the new layers of process that would be mandated by this bill are somehow costless. But the fact is, all of this is going to require money or agency time and diversion of agency resources away from the task of assessing the public's unmet needs and toward the task of reviewing, in many cases, protections that we know beyond a shadow of a doubt are incredibly important, like the removal of lead in gasoline. You can measure the value of that in our children's IQ points. I am concerned that this bill would paralyze the regulatory agencies we need to protect the public and keep them from getting things done to protect the public. I'll wrap up with the suggestion that we do want our businesses to compete with China, but we don't want this nation to become China with the dirty air and the unsafe workplaces that they have to deal with.
Ms. Harnett, I was not mic'd up. Glad to hear from you. Thank you, Mr. Shull. Ms. Harnett, you're recognized.
Thank you. Is the mic on or not? I can't. It is. Okay, great. Good afternoon, Chairman Coble and Ranking Member Cohen. NFIB, the nation's largest small business advocacy organization, appreciates the opportunity to testify on the burdensome effects of regulation on small business and how H.R. 527 would address many of those concerns. Overzealous regulation is a perennial cause of concern for small business owners and is particularly burdensome in times like these when the nation's economy remains sluggish. According to a recent study, regulation costs the American economy $1.75 trillion every year. And more concerning, small businesses face an annual regulatory cost of $10,585 per employee, which is 36% more than the regulatory costs facing businesses with more than 500 employees. Recently, the administration did acknowledge that excessive and duplicative regulation has a damaging effect on the American economy. NFIB believes that it has been a long time coming for small business owners to hear the administration emphasize the harmful effects of overregulation on small business and job creation. We will be watching closely to see if last month's directive leads to real regulatory reform. In the meantime, NFIB believes that Congress must take actions to level the playing field. Congress should expand the Small Business Regulatory Enforcement and Fairness Act and its small business advocacy review panels to all agencies, including independent agencies. In so doing, all agencies would be in a better position to understand how small businesses fundamentally operate, how the regulatory burden disproportionately impacts them, and how each agency can develop simple and concise guidance materials. Moreover, Congress and advocacy should ensure that agencies are following the spirit of SBREFA. There are instances where EPA and OSHA have declined to conduct a SBAR panel for a significant rule and/or a rule that would greatly benefit from small business input. Congress should ensure agencies perform regulatory flexibility analyses and require them to list all of the less burdensome alternatives that were considered. Each agency should provide an evidence-based explanation for why it chose a more burdensome versus less burdensome option and explain how their rule may act as a barrier to entry for a new business. Section 610 review should be strengthened. H.R. 527 would require agencies to amend or rescind rules where the 610 reviews show that the agency could achieve its regulatory goal at a lower cost to the economy. NFIB also believes that Congress should explore requiring agencies to provide updated information on how each agency mitigates penalties and fines on small businesses as currently required by SBREFA, but also require that such a report be completed on an annual basis. Regulatory agencies often proclaim indirect benefits for regulatory proposals, but decline to analyze and make publicly available the indirect costs to consumers, such as higher energy costs, jobs lost, and higher prices. Agencies should be required to make public a reasonable estimate of a rule's indirect impact. Agencies should be held accountable when they fail to give proper consideration to the comments of the Office of Advocacy, and a formal mechanism should be considered for resolving disputes regarding economic cost of a rule between the agency and advocacy. NFIB believes that the Office of Advocacy needs to be strengthened. The office should have the ability to issue rules governing how agencies should comply with regulatory flexibility requirements. Because of improvements inherent within H.R. 527, NFIB is hopeful that review of agency actions will be strengthened and the small business voice will be more substantively considered throughout the regulatory process. NFIB is concerned that many agencies are shifting from an emphasis on small business compliance assistance to an emphasis on enforcement. Congress can help by stressing to agencies that they devote adequate resources to help small businesses who do not have the benefit of inside counsels and HR people to comply with the complicated and vast regulatory burdens that they face. Congress also should pass legislation waiving fines and penalties for small businesses the first time they commit a non-harmful error on regulatory paperwork. Mistakes in paperwork will happen. If no harm is committed as a result of the error, agencies should waive penalties for first-time offenses and help owners to understand the mistakes they make. With high rates of unemployment continuing, Congress needs to take steps to address the growing regulatory burdens on small business. The proposed reforms in H.R. 527 are a good first step. Thank you.
Thank you, Ms. Harney, and thanks to all of you. As I said at the outset, we try to apply the 5-minute rule to us as well, so if you all could keep your responses tersely, we would appreciate that. And at the outset, I want to apologize for my raspy voice. I am coming down with my annual midwinter cold, so I know this doesn't sound good, so you all bear with me. Mr. Sullivan, Elizabeth Warren, the consumer advocate and head of the new Consumer Financial Protection Bureau, has embraced, and I've been told has warmly embraced, the new obligations to comply with regulatory flexibility requirements. Now, most oftentimes, regulatory discussions involve to the right of center or to the left of center, depending upon the position of the advocate. And I would assume that it is my belief that Ms. Warren would probably be to the left of center. If she can embrace these proposals, it seems to me all agencies should be comfortable doing likewise. What do you say to that, Mr. Sullivan?
Mr. Chairman, I agree with you. Elizabeth Warren, who traveled up to Maine a few weeks ago with Senator Snow, actually embraced the amendment that was part of the Dodd-Frank Financial Regulatory Reform Bill, saying that she would have done the type of analysis that we're talking about here today, even if it weren't required by law. So if you had federal regulators with that attitude at every agency, they would be embracing the idea of having small business advocacy review panels, because it is through those panels you get constructive input on how agencies can regulate better, meet their objectives while minimizing costs on small firms. So perhaps after Professor Warren sets up the Consumer Financial Protection Bureau, we can all work to get her in front of other regulatory agencies to preach that type of gospel.
I thank you, sir. And folks, I don't want to in any way imply that I'm advocating compromising safety. I don't want that to come out of this hearing, because I don't want to do that. Mr. Gemmell, what challenges do federal regulations present to your company today as it attempts to create additional jobs in this economy?
Well, the first one is simply understanding what they are. We're a small company. We're a machine shop, and there are literally tens and tens and tens of thousands of pages of regulations that we have to not just comply with, but understand. And I just have to tell you the burden of that is really overwhelming for any single business to effectively do that. We have had, in our case, we have two people full-time that are dedicated to compliance. Much of this is dealing with compliance that is fruitful. Regulations are not something that we're speaking against here, Mr. Chairman. We believe regulation is necessary. We believe protection of the worker, protection of the environment, fair taxation, et cetera, are certainly necessary. What we're talking about here is a process that we feel has resulted in redundant and an inefficient network of sometimes overlapping regulations. And there seems to be a lot of support for that, regardless of what your political orientation is. We have the same objective.
Thank you, sir. Mr. Shaw, you suggest that H.R. 527 would wrap federal programs up in costly, time-consuming, and unnecessary red tape, putting consumers and working families at risk of harm. If a regulation, for example, destroys a small business, would not the working family who's lost his job be in a box?
Well, I think that that would be a concern if that were the case, but there's not really any proof that regulation harms competitiveness of industry, harms jobs, harms trade flows. There's a document I'd be happy to submit for the record that OMB Watch produced in the mid-2000s called Regulation and Competitiveness, as well as an article by an economist, Frank Ackerman, called The Unbearable Lightness of Regulatory Costs. I mean, both of these are documents that exhaustively go through all of the evidence that have, that's been of the studies that have been conducted, and found that there really is no evidence that regulations have harmed U.S. competitiveness or have harmed jobs. Now, I mean, when it comes to, say, jobs, OSHA, for example, is not in the business of destroying jobs. It's in the business of making sure that jobs don't destroy workers.
I'll do it later.
And those are really critical concerns.
My red light's about to appear. Well, the red light has illuminated, so I will yield to the gentleman from Tennessee, Mr. Cohen.
Thank you, Mr. Coble. First of all, Mr. Gimmel, I know you come here with a heavy heart, for I saw the overtime, and it wasn't pretty. You are a Louisville fan as well, I presume.
Well, I'd prefer to think that we are not adversaries, Congressman Cohen, except when it comes to maybe basketball and football.
We're not. I like Louisville, and I was cheering for them last night, and they had a terrible overtime, and I don't
Yes,
share.
I am a Louisville fan, so don't put me in that category with those guys down the road there.
Okay. You mentioned in
Mr.
your
Cohen, if you'd yield, I missed what was the game in question.
Louisville and Notre Dame.
Well, Carolina and Duke were playing yesterday, so I missed Notre Dame and Louisville.
Should I ask who won?
I don't want you to do that.
I won't ask who won. Memphis won, though. I know that. Let me ask you this, Mr. Gimmel. The EPA, you mentioned in your opening remarks. What parts of the EPA would you keep, and what parts of the EPA would you not want to keep?
As it relates to manufacturing, what we see is an overlapping series of, for instance, air quality rules, federal versus local. In our case, in Jefferson County in Louisville, we have two different sets of qualifications that we have to comply with, both of which are very, very complex. Part of that, of course, is a local problem. In the case of EPA, I think what we would like to see is a system that addresses the efficiency of each of the regulations in place, much like President Clinton started in 1993. I believe he called it the National Performance Review. And it wound up eliminating, as it sought redundancy, as it sought out duplicative and no longer necessary regulation or inefficient application of regulation. They were able to eliminate some 16,000 pages of regulations that they determined, the Clinton administration determined was unnecessary at the time. We would like to see that same approach. We are certainly in favor of clean water and clean air, but we think that a lean approach to the process could yield tremendous savings, because our competition is not just with how our economy used to be here anymore. Our competition is global right now. And we're competing against people that operate on a different set of rules, and in some cases, more efficient regulatory processes than we have.
I noted in your remarks you did comment that we need to have clean air and clean water, et cetera, and I appreciate that and that understanding.
And as you point out, we're beneficiaries of that, sir. You're right.
All of us are. The Chinese, of course, as Mr. Schull pointed out, don't have this government regulation in this area. They have it in other areas, and so they have the worst water and air probably possible, but the highest productivity. And I don't know about the Japanese. You mentioned them. I think they're, and Mr. Schull, you might know, but and somebody else here might know, but I don't think the Japanese have got the best air quality. I think they've got some problems there with that. Mr. Schull, let me ask you this. You talked about we talked about the indirect effects that are in the proposed rule. Would you elaborate on your concerns and tell us if you think that anything dealing with indirect effects could result in industry going to court to challenge decisions there?
Sure. So the bill would amend the Regulatory Flexibility Act requirements of these analyses for the effects on small entities by requiring agencies not to just to look at the impacts on the regulated small entities that would be covered by a regulation, but also any small entity outside of the world of regulated small entities for whom there would be reasonably foreseeable economic consequences, adverse or beneficial. It's hard to know where that stops. So for example, if NHTSA really gets on the ball and starts regulating to improve, say, protection of vehicle occupants' lower extremities, NHTSA would probably have to, under this legislation, look at the consequences not just for the automakers, not just for the suppliers who make the parts that go into motor vehicles, but also the car dealers. Now, under recent revisions to the SBA size standards, most new car dealers in this country, somewhere between 83 to 93% of them, would be counted as small businesses. And that includes even a car dealer who makes up to, say, $120 million in receipts. So these are actually not terribly small, not terribly inexpensive, or these are not economically struggling entities. But then when you think about, if you're thinking about the impacts on, say, those auto dealers, they conceivably hire payroll services to handle their payroll. They conceivably hire janitorial services to clean their facilities. They do buy ads from local TV and radio and newspapers. Now, all of those small entities.
Mr. Schull, if you could wrap up pretty.
Oh, of course. It's just it's turtles all the way down. There's really no conceivable limit to what agencies would be forced to assess, and the point at which wealthy corporate special interests could sue them for having failed to consider.
Thank you, sir, and I will, even though the first minute of my time was dedicated to Sports Center, I will yield back the remainder of my time.
The chair recognizes the distinguished gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman, and thank you for conducting these hearings. Mr. Sullivan, I'm going to put your legal acumen on display. Rules and regulations, the violations thereof, can they be evidence of negligence in a civil suit?
Could you ask the question one more time?
Violations of rules and regulations, can they be used as evidence of negligence if Mr. Gemmell is sued in a civil suit?
I don't know.
Do you know whether or not any of the rules and regulations have criminal provisions where Mr. Gemmell could, in theory, suffer criminal consequences because of a rule or regulation that is not promulgated by Congress but is by someone who's unelected, yet he stands to face criminal sanctions if he violates it?
There are some strict liability provisions within statute that are then implemented through rulemakings that do convey strict liability and criminal sanctions, yes.
Mr. Schull made a comment, and I tried to write it down, that there is no evidence, which is a phrase that does strike the attention of a former prosecutor, no evidence that the regulatory schemes have impacted productivity or trade in this country. And judging by your body language, you may have had a different view of that. Do you agree or disagree with his comment?
Congressman Gowdy, I disagree with the comment. I mean, we're living in a global competitive environment right now, and we see different countries trying to both protect the air and the land and the safety of their workers, while minimizing burden on manufacturers and small businesses. And those countries that really do try to strike that balance correctly end up with more employment and more growth. And I fear that the overwhelming amount of regulations that do not take into account how they impact small business will drive businesses away from the United States. So I believe it's a competitive question, and the answer is we can't afford to simply look for evidence on a piece of paper that says, oh, we went too far and we're losing businesses. We have to act now to make sure that that doesn't happen.
Mr. Gilmore, you made the comment that the EPA was out of control. That was one agency that you cited with specificity that that is out of control. Can you give me a specific example of that? And also, if you were to get a call from a regulator, the perception, because you embody small business, the perception that you have as a small businessman, is it one of we are here to help you, or we are here to get you?
Well, first of all, Congressman, with regard to the EPA, the ozone regulatory functions that the EPA seems to be taking on, we believe, are overstepping. There's no question about that. What was the second part of your question?
Whether or not there's a perception among small business owners that the regulatory entities in this country are there to provide help, or there to or lay in wait to catch you doing something wrong.
Well, that's more than a perception, sir. I think that's a reality, particularly when it comes to the new attitude at OSHA. Workplace injuries have been at record lows, historic lows, for the last several years in this country because of, I think, largely a cooperative relationship between businesses and the regulatory agencies. We could call them in, ask them for advice, ask them to take a look at part of our plant that we're reconfiguring or that we may have questions about, and get their input without fear of consequences. Now, the attitude at OSHA is, we're going to get you. If we come in, you invite us in, and we find something, you're going to get a big fine. So it's more of an adversarial relationship now as opposed to a cooperative relationship.
Last question, Mr. Schul. The President himself has acknowledged that there are regulations that have an unintentionally deleterious impact on job creation and industry. We've got about 45 seconds left. Can you list me 4 or 5 regulations that you would concede have had unintended, pernicious, deleterious consequences on industry?
You know, I've been waiting for the President to offer some specifics to
In
justify his
in lieu of his presence, would you give me some? Would you give me just a handful of regulations that you concede, out of the myriad ones out there, you concede have had an unintendedly pernicious impact on job creation?
Actually, yes. The fuel economy standards were set too low and have stayed too low for too long, until just recently. That meant that the U.S. automakers were not prepared to compete when gas prices spiked, and they had these heavy gas-guzzling SUVs.
Mr. Shull, I'm not buggy whipping you, but wrap it up if you will, because the red light's on.
Right. Well, then that's one that I would list in addition to the failure of the automakers to make SUVs that perform well in crashes. They really suffered significantly when the Ford Firestone debacle came to light.
Thank you, Mr. Chairman.
You bet, gentleman's time expired. The distinguished gentleman from Illinois, Mr. Quigley.
Thank you, Mr. Chairman. And again, congratulations on your new position. We appreciate your cordiality and accommodations. Mr. Conyers talked about how quickly this bill has come to a hearing. What's interesting is this is, I think, my 5th meeting already between my 2 committees on the issue of regulations. If we can squeeze one more in this week, they tell me I get a set of steak knives. So, but here's what's interesting, folks. We're basically saying the same things, as the chairman said, just on the either side of this middle ground line. We all recognize the need for regulation. We just want it to do a better job. I think that's what the President talked about. And as I've said before, I dare anyone in this room not to think of regulation the next time you get on a commuter airline. Or if you come to my hometown and you drink tap water, right? Chicago, not the lake water, the water from the tap, which has levels of chromium, not healthy for you, 3 times what's been judged to be a healthy standard. So we get we're not perfect, and it has to improve. And I recognize that for some this is even more offensive because non-elected officials are actually part of the enforcement mechanisms. But we recognize that under Democratic and Republican administrations, our laws and our regulations have always had criminal penalties to them out of absolute necessity, enforced by non-elected officials. If you take it to its extreme, assistant state's attorneys aren't elected. Their bosses are. Well, the same is true with the executive branch. FBI agents, police officers. So I think we need to recognize it's important to let the public know there's a balance here. If we come off that the only message here is that regulation is what's killing people, that killing jobs, we forget that a lack of regulation can kill people. So I sense in these now 5 meetings that we're all getting to sort of the same point, and we have to do better. We have to avoid duplication and redundancy, and to make if we want to get to the same goal, there might be more efficient ways to do that. So to the extent that we can do all that, that's fine. I just ask that we try to use the same numbers. So when we talk about these, what I'm trying to get from both sides is why one figures are better than the other. And while we only have a few minutes today, let me just ask the first, because it's such a prominent number that's being thrown out there. Mr. Scholl, the Crane study threw out the biggest number so far, so it wins. But can you tell me, beyond what you said in your written documents, what you see the concerns are with that report?
So the concerns, and these are concerns, by the way, which have been identified by a range of folks. The Center for Progressive Reform on the one hand, and President Bush's former administrator of the Office of Information and Regulatory Affairs on the other hand. Folks from a variety of viewpoints have recognized that this study and its previous iterations is deeply, deeply flawed. And it comes out with this number that is so easy to cite and memorize and use and repeat. And understandably, because it's so large, folks are going to quote it and be alarmed. But it seems to be the result of a garbage in, garbage out process. I mean, the Crane and Crane, or Crane and Hopkins, or Hopkins studies have repeatedly used really shaky methodologies. For example, the key formula using the Regulatory Quality Index from the World Bank is based on public opinion surveys. The costs of environmental regulations depend in large part on a 20-year-old study by Hahn and Hurd, which itself used 30-year-old studies produced by conservative economists to produce its numbers. There's a really strange study by Joseph Johnson on the costs of occupational safety and health regulations, which nobody can figure out quite why he did what he did and how he got to the numbers he got. It's a very opaque document that actually takes some old numbers and then multiplies them by 5.5. You know, at the core of this is a presumption that regulatory costs are always the same year after year after year. Even after businesses learn how to adapt to the new climate and innovate and discover new ways of doing business that are actually far cheaper than they realized going in.
But because we're running out of time, you do recognize there's a cost, and we try to keep those to a minimum. What I'm trying to get both sides to do is to work with the same numbers. The hyperbole exists on both sides of the world here. So if any one of these panelists, Mr. Chairman, have the opportunity to submit further evidence, arguing, footnoting as best research as possible toward their ends on what numbers we really should be dealing with, it's useless if we're not dealing with real numbers in the real world. Whatever they are, they're important. So I just respect that we could work in the same ballpark and same universe of reality.
I thank the gentleman from Illinois. Thank you. I didn't have to cut you off that time, Mr. Scholl. The distinguished gentleman from New York, Mr. Reed, is recognized for 5 minutes.
Well, thank you very much, Mr. Chairman. Mr. Shull, I'm trying to understand your testimony, and what strikes me is, you know, I listened to my colleagues on the other side. I listened to reading the testimony from our side. I listened to the president acknowledging that everyone seems to agree regulations are causing a negative impact on small business America. Yet, when I read your testimony, what I'm coming away with is you talk about there being a better way than H.R. 527 to deal with this issue. And my interpretation of your testimony is that it's essentially, it's a way we should be increasing regulation, subsidizing small businesses to allow them to comply with that regulation, and then tax the people to pay for that subsidy for small businesses. You know, isn't that the classic Ronald Reagan situation? You know, where it's essentially, if it moves, tax it. If it keeps moving, regulate it, and then if it stops, subsidize it. I mean, do you agree that the regulation problem is causing a negative impact on small business?
Well, I suppose I'm afraid of the other Ronald Reagan problem, which is delaying regulations to the point that children are dying or people are at risk. I mean, for example, the Reagan White House delayed a simple warning label on aspirin products to notify parents not to give this to young children when they have flu or flu-like symptoms because of the risk of Rice syndrome. The Reagan White House delayed that standard, and in the course of that, thousands of children were afflicted by Rice syndrome and suffered irreversible brain damage, liver damage. Some of them died. You know, I suppose I'm also afraid of the other Reagan problem, which is, you know, the cutting things to the bone and then running major deficits and, you know, leaving the public at the risk.
But Mr. Shaw, I'm not talking about Reagan's problem. I'm talking about your concept that what we need to do to cure this problem is create more regulation, and then the people that can't comply with the regulation, let's give them a tax subsidy in order to allow them to comply. I guess I just don't see how more regulation is going to correct this situation.
Well, first of all, the subsidy concept was one that was jointly authored by Senator Snowe and Senator Kerry for legislation that would actually not subsidize small businesses, but the small business development centers, I believe that's what they're called, to provide technical assistance to small businesses so that they can actually comply with the law. I mean, if the challenge is that they don't know what the laws are and they need help learning what they are so that they comply, it seems to me that the solution is not to get rid of the law that's there to protect people, including the small business owners and their families, but the solution is to help them learn more about it.
So essentially, we're here from the government. We're going to take care of you.
Or, I mean, if they would rather hire, you know, private industrial hygienists or, you know, other folks to help them comply, I suppose that's fine. It's probably cheaper if it.
Well, the taxpayers have to foot that bill. I mean, I guess I'm a small business guy. I come from a small business, and I've just dealt with these regulations, and I can just tell you firsthand that, you know, there's a real cost, and that destroys businesses that otherwise could use that money to invest, to capitalize their markets, to move on to the next innovation of tomorrow. And I guess, Mr. Kimmel, I mean, you're a small business man. What's your response to his proposal where do you see that going?
I would ask him if he's ever run a business that had to comply with any of the array of regulations. I'd be surprised if he would make a statement like that and having a background of actually running a business.
Mr. Shaw, have you ever ran a business?
My time has been spent in advocacy, working with families who've suffered incredible losses because of the lack of regulation.
Well, and I understand that. I mean, we live in a real world, and I understand that many people come to this table, come to this chamber, come to this hall for good intentions. We don't want to hurt people. As the chairman said, nobody wants, you know, we want clean air, we want clean water, and I think I echo my colleague over on the other side that said, you know, we want the regulations to have a good effect. But what the problem is by creating more and more regulations, we're losing sight, in my opinion, as to what we're trying to do. And all it becomes is, you know, guaranteeing a way to more regulations so that if it's good for one situation, it must be good for all. And that's my concern. And because, you know, as a small business guy myself, this gentleman here, people are suffering. And those are real jobs, and those are real Americans. I see that my time has expired. I'll yield back.
I thank the gentleman from New York. I just conferred with Mr. Cohen. Mr. Ross will be the final witness or the final examiner. And if no one else shows that interest of your schedules, we will adjourn after we hear from Mr. Ross. Mr. Ross, the distinguished gentleman from Florida.
Thank you, Mr. Chairman. Mr. Sullivan, a question for you. When we talk about regulation for small business, I'm reminded of the Americans with Disability Act, the ADA, which has had some unintended consequences, but nevertheless, which put a requirement on business for accessibility for those with disability. But in that ADA Act, it had what was known as a reasonable accommodation standard. For example, if I was CEO of a Fortune 500 company, a reasonable accommodation for an employee with one type of disability may be something that I can afford to do with a modification of the workplace or access to the workplace. But if that same employee with that same disability came to me and I was an employer of 4 or 5 employees, that reasonable accommodation probably could not be made. So my question to you is that under the RFA, is there any such standard of a reasonable accommodation that would fit the regulatory environment to allow small businesses to meet the regulatory burden without having to have a broad brush approach as for the larger ones?
Congressman, the situation that you laid out is exactly what H.R. 527 is trying to address. Because what we found is if agencies alone look at what constitutes reasonable accommodation, they may not get it right. But if they are forced through this law to sit down with small business owners, disclose what the direct impact of a proposal will be, disclose what the ripple effect of that proposal will be, and then actually listen to the input from small businesses and constructive ideas on how to get the regulation right, then that final rule that they come out with is much more likely to be a balance.
Right. And it is about a balance, isn't it?
Yes, than it is without that process. And that's really what this bill does, is it forces that process.
Thank you. Mr. Scholl, when you talked about in your opening statement about how if it were not for the regulatory environment, the auto industry probably would not have had seat belts or collapsible steering wheels, and you seem to indicate to me that if there not had been a regulatory environment, that some of the safeguards that consumers now enjoy would not be in place. But yet I have to look back to even the founding of our country when there was no regulatory environment, and when Benjamin Franklin was one of the investors of the first fire insurance company, in order to manage that risk, they created the first fire department. And as we've seen throughout history, that our market forces have allowed us to find that balance. And in fact, in the auto industry, we've seen a balance because of insurance companies insuring a product requiring certain manufacturer specifications. Otherwise, they wouldn't insure it. Otherwise, they wouldn't give you the appropriate coverage to manage that risk. And so my question to you is that as a businessman, if I were going out there and wanting to start a business and I wanted to make sure that I could meet the needs and have a profit, I would want to look at such factors such as demand. And if there was no demand out there for my product, then I probably shouldn't go in business. Is that correct?
Sure.
And if there were no natural resources or whatever it was I wanted to sell, if I could not produce the product, even though there was a demand, it would probably be indicative of the fact that I shouldn't be in business. Would that be correct?
Or it might be indicative of the fact that you haven't found the right buyer.
Okay. But would you go into business if you didn't have those? If you could not make a profit at it?
Well, I've spent all of my time in the nonprofit sector, so it's not the question to ask me. I'm sorry.
Well, then the question to ask you would be, if I were a business
Sure.
that was burdened by regulation to the extent that I could no longer turn a profit, is that indicative of the fact that maybe I shouldn't be in business at all?
Well, it might be a sign that you were undercapitalized to begin with, or that...
If I was undercapitalized, would that be because I could not afford to comply with regulatory environment despite the demands of the consumers for my product?
Well, this is a hypothetical, but if you put this in the concrete terms, if a small automaker is trying to get in the business of producing vehicles, but doesn't have the wherewithal to produce a vehicle that's actually safe and crash-worthy on the nation's highways, that's not necessarily an automaker we necessarily want in business in this.
So in other words, that irrespective of market forces, the regulatory forces would be a good judge of why we should even be in business in the first place.
You know, I guess I have to take issue with the concept that markets are conceptually and historically prior to government. I mean, they exist
not a bad thing.
simultaneously, and governments create markets and create the vehicles, the infrastructure that allow markets to flourish, from our roads to the fact that the legal status of corporations.
I see my time's up. I must yield back.
I thank the gentleman. Steve, everything cool?
Everything's fine. I thank you, Mr. Chairman, and I want to just thank the panel. It was excellent, and while it wasn't reality TV, it was good.
I want to thank the panel as well. And Mr. Ross, I'll say to you, if you had another question, we will keep the, we'll keep this open. Members will have 5 legislative days to submit to the chair additional written questions for the witnesses, which we will forward and ask the witnesses to respond as promptly as they can so that their answers may be part of the record. Without objection, all members will have 5 legislative days to submit any additional materials for inclusion in the record. With that, again, we thank you all. As Mr. Cohen said, it's been a good hearing. Thank you for your contribution, and we're letting you all leave early as well. The subcommittee stands adjourned. Thank you, Steve. Okay.